Well, good afternoon, everybody. I think we're just on 12 noon now, so we will commence this webinar. So a warm welcome to you all. We're going today to talk about the topic of the law in relation to do not attempt cardiopulmonary resuscitation decisions, which is a bit of a mouthful. DNA CPR, I think, is the commonly adopted shorthand, a highly topical area, one that's received attention even in recent months as a consequence of their use in the pandemic. And you'll be hearing today mainly from my colleague Charlotte Radcliffe, who is an associate in the clinical law advisory team here at Capsticks. My name is Adam Hartrick. The webinar, just a few housekeeping points. The webinar is being recorded. We will share the link after the event with those that have attended, and you can then revisit the content and share it with colleagues as you see fit. If you experience any technical issues during the course of the webinar, then we would ask you to raise those in the chat box. Someone will be monitoring and looking at that. In relation to any questions, we are running a live Q&A and we'll have some questions at the end of the webinar. So if you do have questions, please could you put them into the Q&A box and we will be monitoring that as we go through. You'll be able to see questions that are being put in there by other participants, and you can like them, and that might bump them up the list and means that they're more likely to get answered. If we do run out of time, and we will be finishing at 1, then certainly we will aim to follow up afterwards with any unanswered questions. There will be a feedback form following the webinar, so we would ask you to please take the time to complete that so that it certainly helps us improve our webinar events. So without further ado, she's got a lot of material to get through. I'm going to hand over to my colleague, Charlotte Radcliffe.
Thanks very much, Adam. As Adam's explained, I'm going to be talking about DNA CPRs, DNARs, do not attempt cardiopulmonary resuscitation decisions, which, as Adam says, is a bit of a mouthful. So on the agenda for today, firstly, I'm going to set out some case law background. So the Tracy case from 2014, the Court of Appeal decision, is the predominant DNAR CPR case. So I'll be talking a bit about that. So there are definitely some learning points to take forwards. Then, as Adam also mentioned, the CQC carried out a review of DNARs during the pandemic recently, so I'll be touching on that as well. And then moving on to the general grounds for DNARs that I could think of, and I'll be interested if anyone wants to put in a Q&A whether they could think of any other reasons for placing a DNAR on a patient's medical records when we get to it. Then futility, because I think that is probably the hottest topic of all, and can cause clinicians some difficulty, I believe. Then essentially a brief bit about the Mental Capacity Act 2005, where the patient lacks capacity, how to go about making decisions in their best interests. So I'll be touching on the Act itself, the capacity test, best interest checklist, etc. Then moving on to IMCA referrals, again related to where the patient lacks capacity, second opinions, and then lastly, a bit about advanced decisions, because they can often be relevant. So, case law, the Tracy case, which if you know anything about DNARs, then you probably have heard of the Tracy case, if not in name, then the substance at least. The facts, just to reiterate, a bit of a whistle-stop tour. The first DNA CPR notice was placed on Mrs. Tracy's records on the 27th of February without consulting the family. The family discovered this on the 2nd of March and objected. That DNA CPR was then cancelled. Mrs. Tracy deteriorated subsequently on the 3rd to the 4th of March. And a second DNA CPR was agreed with the family on the 5th of March. Mrs. Tracy then deteriorated and died on the 7th of March. So the family alleged, when bringing a claim, that the first DNA CPR notice infringed Mrs. Tracy's Article 8 rights by the following failures. So not consulting adequately with Mrs. Tracy or her family, not notifying her family of the actual decision once it had been made, not offering them a second opinion. They claim that there was no DNA CPR policy available. And they said that any policy that would be available would need to be clear and unambiguous. So a bit about Article 8, because that's sort of littered throughout the case and formed the basis of their allegations and their complaints. So Article 8 of the European Court of Human Rights essentially is the right to the respect for a private and family life. Essentially, it's the right to determine your lifestyle, control of who you see and touch, etc. It's not an absolute right. There are some legitimate restrictions on the operation of Article 8 with respect to certain medical procedures. It says as follows: there shall be no interference by a public authority with the exercise of this right, except such as in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, and then the important bit, for the protection of health or morals, or for the protection of the rights and freedoms of others. So do note that just because Article 8 may be engaged in any case, it does not mean that it has been breached. And that's a very important distinction. So Article 8 may be relevant, but that doesn't necessarily mean that it's been breached. And then the Tracy judgment essentially sets out when clinicians need to consult patients and family members. The starting presumption is that if it's life-sustaining treatment, and CPR would be, then you need to involve patients, or you should involve patients in discussions about that. There need to be convincing reasons not to involve patients or their families. And there may be good reasons for not consulting them, particularly where harm may be suffered. But be careful about using that exemption. I've set out two quotes below, one from the judgment and one on another case that are particularly that are of interest. The first says, the court should be very slow to find decisions based on distress violate Article 8 rights if conscientiously taken. And you compare that with, in my view, doctors should be wary of being too ready to exclude patients from the process on the grounds that their involvement is likely to distress them. So essentially, it's a balancing act. And if you are going to make a decision that a patient or their family is not going to be involved in discussions about a DNA CPR, then just make sure that you've thought through those reasons very carefully and that they're considered. So where treatment would be futile and DNA CPRs are quite often, if not sometimes at least, put on patients' records on the basis that CPR would be futile. The most important part of the Tracy case found that patients should still be informed of that decision, even if treatment is viewed as futile. So the clinicians may have made their decision and may not feel it necessary to involve the patients in that clinical decision, but they still need to inform the patient and all their relatives of that decision. And that's incredibly important. The duty to consult involves a discussion, where practicable, about P's wishes and feelings. And it's better undertaken at the earliest stages of the clinical relationship so that decisions can be reviewed as circumstances change. I think it's better all round if a DNA CPR decision is made as early as possible to provide clarity to the clinicians at the very least, should the need arise. The duty to consult is integral to respect for the dignity of the patient. So it's a strong duty. The other topic that Tracy touched on, which the family raised in their allegations, were the trust policies. So the judgment emphasised that any policy that engaged a patient's rights under Article 8 must be accessible and clear, with patients made aware of their rights in relation to involvement in decision making. And that's set out in paragraph 66 of the judgment, if you happen to be flicking through it. Trust should have in place a policy which is accessible to the individual who is affected. The policy should accord with the Resus Council's joint statement, so their guidance. A leaflet can be helpful to summarise the policy for patients and families. And the policy can say that the last word sits with the clinical team as to futility, the clinical decisions that need to be made. Obviously, if it's a best interest decision, then the last word may ultimately have to sit with the court, but we'll come on to that. So the CQC carried out a review last year, following concerns and complaints raised that care homes, I think in particular, and hospitals had imposed blanket DNARs on various, particularly elderly patients, without giving proper and due thought and consideration. The interim report was published in December 2020 and is available online. Fortunately, CQC found that there were some examples of good practice, and I certainly don't think that the report was quite as scathing as some might have anticipated. But they found that there was a real issue with people not being involved in decisions, poor record keeping, a lack of scrutiny, and a lack of oversight. There were definitely some criticisms made, and fairly widespread criticisms. They did note, though, that there were mitigating factors involved, and as they called them, significant barriers, and that those were the pandemic, which obviously created a hugely pressurized environment where decisions needed to be made quickly about a number of clinical issues, and a lack of training and a large amount of rapidly changing guidance. So when drafting the slides for this talk, I thought it would be helpful to set out, as I saw it, the grounds for the various grounds for placing a DNA CPR on a patient's medical records, just to help provide a bit of clarity with this discussion and focus. So the first is where a capacitous patient requests that a DNA CPR is put on their file. The second is where it's a clinical decision, i.e. futility, so CPR would be futile. The third is where treatment may be successful, but the patient lacks capacity and it's a best interest decision. And the fourth is, it's essentially the first point, but slightly amended. So a request from a legally appointed guardian, LPA or deputy. So futility. Interestingly, the Resus guidance doesn't actually use the word futile or futility throughout the guidance, but it is mentioned in their submissions in the Tracy case, which I've got a quote just midway down the slide for you on that. So the Resus guidance says that where CPR will not be successful, that's a clinical decision. Essentially, that's their definition of futile. Or equivalent rather. The Resus section 5.4 says that if the healthcare team has good reason to believe that CPR will not restart the heart and breathing, again, that's a clinical decision that they can make. The Resus submissions go further than that, though, which I think is very interesting, and I think really helps set the parameters for for futility in this context. And this particular submission is at paragraph 51 of the judgment. And it says CPR is also unsuccessful in circumstances where it will merely prolong the dying process for a matter of hours or days. CPR can properly be considered to be futile in such circumstances. And I think that's a really important insight into the Resus Council's thoughts on futility and on CPR. Now, the difficulty is comparing that with situations where treatment would not be considered futile, and the Resus guidance defines that as where CPR may be successful. So that is where there is a chance that it could be successful. It's not on the balance of probabilities, so it's a fairly low bar, but that's where you're straying out of the realms of futility. I think the important point to note here and to take home is that patients have no legal right to treatment that is clinically inappropriate or that clinicians are not prepared to provide. And that is a very solid grounding for clinical opinion and decisions. And do bear in mind and remember that clinically inappropriate, the phrase clinically inappropriate, is not a best interest decision. They are two distinct issues. For me, at least. Clinically inappropriate is a clinical only decision based on the clinical facts available, whereas a best interest decision is a holistic assessment of a particular patient's wishes and feelings, benefits, disbenefits of that particular care provided to them. So they are two different things. And obviously, when you're making a best interest decision, you do take into account the clinical facts. But they are two different points. So speaking of best interest decisions, I thought we'd move on to situations where P lacks capacity, where the patient lacks capacity, and the best interest decision-making process. So this slide just sets out an overview of that process. You start with the capacity assessment, and I'll come on to the criteria for that in a second. Consult family or friends if the patient has any. Obviously, consult the patient themselves if you can. Consider whether an IMCA needs to be involved. So if the patient has no family or friends, then that may trigger or fulfill the criteria for a referral for an IMCA. Consider carefully the patient's wishes and feelings. And that is paramount, really, to any best interest decision. It's what are and what were P's wishes and feelings, and that includes their previous wishes and feelings, ideally when they had capacity previously, if they had capacity previously, and what are their current wishes and feelings now. They may not have capacity, but they obviously will still have, well, in most cases, they will still have some sort of wishes and feelings if they're able to communicate them. And then lastly, the best interest meeting. And that's when you then make a best interest decision. And in that best interest meeting, you discuss obviously everything that you've gathered, all the information you've gathered from your consultations. You involve family, friends, IMCA, and anyone who you have consulted in that decision, in that meeting. It's a collaborative process, and that's the nature of the court of protection work and best interest work, is that it is collaborative. So section 2 of the MCA, the Mental Capacity Act 2005, sets out the capacity test. So it's in 2 stages. The first stage is the diagnostic threshold, where the Act says a person lacks capacity if at the material time, he or she is unable to make decisions for him or herself in relation to the matter because of an impairment of or disturbance in the functioning of the mind or brain. Now, that may be a temporary disturbance, and that's a key consideration. Is the patient likely to regain capacity again? But that is the first stage. Once that's fulfilled, the second stage of the capacity test is the patient's subsequent inability to make a decision, which is set out at section 3 of the Mental Capacity Act. And that states that where a person is unable to make a decision, if he is unable to understand the information relevant to the decision, retain that information, use or weigh that information as part of the process of making the decision, or communicate his decision. And if any of those criteria is not met, then that's potential grounds for a conclusion that the patient lacks capacity. And do bear in mind with the communication criterion that just because a patient finds it difficult to communicate verbally does not mean that they can't communicate. So if they do struggle to communicate verbally, but they can communicate by other means, you must make an effort to communicate with them by those other means. So if they have assault, for example, then get those involved. So once you've carried out the capacity assessment, if P lacks capacity, then you move on to the principles of the Mental Capacity Act. And I've set them out on this slide. The principles are the best sort of place to start, really, when considering a best interest decision, and clinicians should always have those at the back of their mind. So the first is the presumption that an individual has capacity. The second is that the patient needs to be involved in decision making as far as possible. The third is that the patient is not to be treated as unable to make a decision merely because he or she has made an unwise decision. The fourth is the need to ascertain what is in the best interest of the patient. And the last one is that healthcare professionals or anyone must take care to use the least restrictive intervention available. Section 4 of the Mental Capacity Act, also set out in Chapter 5 of the Mental Capacity Act Code of Practice, sets out the decision-making process for professionals to follow. So Section 1, Subsection 5 of the MCA says an act done or decision made under this Act for or on behalf of a person who lacks capacity must be done or made in his best interests. And helpfully or unhelpfully, rather, best interest itself is not defined within the Mental Capacity Act, probably because it's too difficult to articulate exactly what best interests involve or should mean generally amongst the population, because it is such a specific decision and specific issue to each particular patient. But helpfully, the Mental Capacity Act, Section 4, does explain that when determining best interests, you should take into account the following. So you must consider all the relevant circumstances, also whether the patient is likely to regain capacity, because if the decision can wait until they've regained capacity, then fantastic, just try and hold out until they can make a capacitous decision. Permit and encourage the patient to participate. Any decision made must not be motivated by a desire to bring about death. And that is distinguished from a clinical opinion that it's no longer in the patient's best interest to continue receiving treatment. I think that's potentially an ethical distinction, but it's an important one. So the remaining issues, the remaining criteria are past and present wishes and feelings. So as I said previously, it's very important, it's of paramount importance that you take into account the patient's past and present wishes and feelings, that you consult named persons, so friends, family. If carers are very well known to the patient and have been caring them for a while, for them for a while, and know them and understand them, then they could be a useful source of information. And then the last is the benefits and disbenefits checklist, and that's a fairly factual task of setting out the benefits of the proposed treatment and the disbenefits. So in terms of that benefits, disbenefits checklist, the first thing to remember is that it's incredibly personal to each particular patient. And in order to complete a benefits and disbenefits checklist, and there will be some clinical aspects to that clearly, there will absolutely be clinical aspects that are objective to the checklist, but the whole point of a best interest process and decision is that it's not just clinical aspects, it's also very personal. So what do you know about P, and what would P want? The sorts of questions to ask yourself when completing this sort of checklist is whether the patient is likely to experience unmanageable or long-term pain or other distressing side effects as a result of treatment. And if so, what would the patient think about that? Is there any reason why the patient may want to stay alive for longer, even if there is a risk of pain? Do they have any particularly strongly held religious beliefs? What are their views on death? And also, I think this is probably the most important question, really, is what sort of quality of life is acceptable to P? And that's not an objective question. And I think clinicians need to be very careful they don't impose their own views on quality of life on the patients. Obviously, their clinical views on quality of life are very important, but that's a separate issue to the patient's own views on their quality of life. So that's the benefits, disbenefits checklist. You've consulted all the family members, you've had your best interest decision. And then the question is whether you need to take matters further and make an application to court. And if there is an ongoing dispute, then it seems likely that there will need to be an application to court. And that's a dispute about a patient's best interest where that patient lacks capacity. So if at the end of the best interest decision meeting, there is a dispute, then you need to consider how to take matters forward. The first step, I would suggest, would be to seek legal advice, whether that's from your internal in-house lawyers or outsourced to us, or both. Tell any other parties who should be involved in that decision that there is a dispute and that you're considering how to resolve that dispute. Consider mediation. It can be successful. I have often found that if a patient's family's views, the family's views are so entrenched and strongly held, it may be that mediation is actually likely to be futile. But it's important to consider it in any event, because, as I say, it can be successful. And it would be a lot cheaper than having to go to court and take a lot less time. So if not formal mediation, then consider getting an objective third party in to try and bridge the gap between the clinicians and the family. Quite often, best interest decisions, where there is a dispute, it's often there's often a miscommunication or a misunderstanding of the true position, and it sometimes can help to get a third party in, an objective third party in, to help communicate that clearly. And then the last resort, if all else fails, is making an application to court, and that's something to consider at all stages. And if you do think you're going down the track of an application to court, then it is best to seek legal advice at as an earlier stage as possible, because it does take time to prepare the application and make it. So do bear that in mind. So IMCA referrals are particularly relevant to best interest decisions, because IMCAs are heavily involved, can be heavily involved in the best interest decision-making process. Section 35 of the Mental Capacity Act sets out the introduction for IMCAs, so that's how they're created. And the criteria for serious medical treatment referrals is set out at Section 37 of the Mental Capacity Act, where it says, satisfied that there is no person other than one engaged in providing care or treatment for P in a professional capacity or for remuneration, whom it would be appropriate to consult in determining what would be in P's best interests. A family dispute is not a reason for a referral. If there is a family involved in the decision, then it is extremely likely that an IMCA would reject a referral on the basis that there are technically others involved in the decision that are known to P. It can sometimes be a little frustrating when you don't think that the family members have P's best interests at heart, or at least don't understand them or understand the sort of decision they need to make. And it would be helpful to have an IMCA involved in that dispute, but that's the IMCA criteria. There are many services spread over England and Wales, and they are incredibly oversubscribed, as I understand it. So if you do think that a case would benefit from an IMCA referral, then do make one. But just a word, a note of caution, if there is a family involved, then it's likely they'll come back and say, unfortunately, they can't assist. Worth trying though, anyway. And second opinions are another common issue with DNA CPRs that I see. The resus guidelines set out at page 4 of paragraph 12 in the main messages, where a patient or those close to a patient disagree with their DNA CPR decision, a second opinion should be offered. Now, that word should is key. It doesn't say must, it says should. And where it says should, that means that clinicians should try and offer a second opinion wherever possible. It may be that in some cases, it's not possible to get a second opinion. For example, if a decision needs to be made very urgently and there's absolutely no time, or if it's in the middle of the night and you can't get a hold of anyone else, and a second opinion just isn't available. I would think that that second scenario is very unlikely to arise. There will surely be someone else in the hospital available to help, I would have thought, in quite a lot of cases. But I think it's important to know that if you can't get a second opinion and you have tried, you don't need to. It may be that if you've tried overnight, for example, and you can't get one, then you can the next morning, and you should get one the following morning. But do bear that in mind. So you're not obligated to get a second opinion. I say that, but they can be extremely useful. So I do recommend that wherever you can, do get a second opinion, because it just provides clinical support to the decision made by the clinicians in the case. If it doesn't support the clinical decisions in the case, then obviously that's good clinical grounds for reconsidering the decision that's been made, and helpful. The GMC, treatment and care towards the end of life guidance, helpfully says you should explain your reasons and any other options that may be available to the patient, including seeking a second opinion. So again, GMC says you should explain. That doesn't mean that you have to in all circumstances. And as I say, if you can't, and you have good reasons for that, then don't worry. The last point I wanted to make on second opinions, and I get asked this quite often, is who should clinicians get second opinions from? And the answer is the further removed, the better, really. I think if certainly outside the clinical team treating the patient, if at all possible. The next step outside of that would be another clinical team within the hospital. The next step further removed from that would be within another hospital within the trust potentially, or a neighbouring hospital. So a truly external second opinion. Obviously time might dictate and urgency might dictate how far removed you can go in any particular case. But do all you can to make it as objective as possible. And I should say also that with that second opinion, that can then help any disputes that there is between clinicians and families, and could be of great assistance with any potential informal or formal mediation where you're trying to resolve that dispute. It's an objective third party, a clinical opinion. Advanced decisions. These are often relevant to DNA CPRs. And I thought worthwhile running through them in this webinar. So advanced decisions are for refusing treatment, not demanding treatment, and that's the first important distinction. The criteria for a valid advanced decision is that the patient must be over 18. It must have been written by the patient or completed by the patient if it's a form, signed by the patient and by a witness. And most importantly, it must be specific about the treatment that they are refusing and the circumstances they are refusing that treatment, particularly where that treatment is life-sustaining treatment. So it really needs to be specific. That not only potentially validates the advanced decision, it just absolutely helps clarify the parameters for the advanced decision for any clinicians providing treatment in the future. If it is valid, it is legally binding. And often clinicians, when reviewing an advanced decision with a view to either providing a patient with treatment or not providing them, as the case may be, with treatment, clinicians should consider whether the patient has done anything after making that advanced decision that would render it invalid. Now, obviously, simply asking the patient in most cases would be sufficient to answer that question. If you can't ask the patient, then their friends or family. It may be that the patient's been in hospital for a long time and you've witnessed things that they have said that would render the advanced decision invalid. But that is an important point. And the last important point to note is that if P has made an advanced decision and then appointed an LPA after that, then the LPA can override the advanced decision on the basis that the patient, knowing that they had the advanced decision in place, then made the decision to appoint an LPA. And the LPA then has the ability to override the advanced decision. If it's the other way around, then generally the LPA can't override that advanced decision. But that's a very important point that I think that is, may potentially be often overlooked. That was all that I had on my slides and wanted to say about DNA CPRs. I'm not sure, I haven't been able to check that. The Q&A has 12 messages in it or so hopefully we've got a few questions to keep us busy.
Thank you, Charlotte. Yes, thank you very much for that, and thank you for the questions that have come through. Just a very brief comment. I think that key here to this whole topic is communication with patients and families, communication about what DNA CPR is and what it isn't. It's not, ending all care and treatment, but it's very specific. And also an understanding of the prospects of success of CPR. And of course, whilst this was an extremely happy outcome, the general public perception may not be assisted by examples such as those which occurred on the football field a couple of weeks ago, with a young, fit, healthy footballer collapsing and having CPR, and very thankfully it's succeeding, and he's sending text messages the following day. Nobody would be suggesting a DNA CPR on a patient of that profile. It's not that sort of patient that we are talking about. But to have a look at the questions then, so I'll take them in the order that they are on the screen. And as I say, if we don't get through them all, we'll certainly happily send out written responses to the people asking the questions. So the first question: occasionally a CPR status has not been discussed and documented before the patient is peri-arrest. Can the arrest team decline CPR on the grounds of futility at that stage? Charlotte, do you want to address that one?
Sure. Yeah, I absolutely. If a clinical team at the point that CPR needs to be provided take the clinical view that it would be futile to provide that CPR, then yes, they can. I think this touches on one of the issues that I mentioned in the talk, whereby timescales may be a factor. So absolutely try and make these sorts of decisions as early as possible to avoid an urgent decision needing to be made peri-arrest. But failing that, if that's not possible, then if there are grounds of futility, then that's sufficient to make a DNA CPR decision at that stage.
Thank you. So the next question, which has also received a few likes, it's just disappeared from my screen for a moment. Here we are. I'm particularly interested in temporary suspension of DNA decisions. Example is given of managing a patient with such bad COPD that they would not be suitable for intubation or ventilation and thus have a DNAR established, but who would benefit from surgery for a hip fracture. And secondly, I think this is a distinct question, who ought to receive resuscitation if they become, e.g., profoundly hypotensive from anaesthesia? So taking the first point about temporary suspension of DNA CPRs, Charlotte, do you have any comment on that?
Yeah, so a DNAR, I suppose, would you be suspending it temporarily for the hip fracture whilst that's being carried out?
Yes.
And that, I suppose, so one of the key issues when considering whether to place a DNAR on someone's file is what reasons might there be for them suffering a cardiac arrest. And for example, if they suffer a sudden cardiac arrest, as Christian Eriksen did when playing football, that is easily recoverable, where CPR is likely to be successful and recover him back to the position he was in before, then I think that CPR should be provided in those circumstances. I suppose if that situation could arise in hip surgery, then and the patient suffers a cardiac arrest, which you think could be easily treated and recoverable with CPR, then I see no reason why CPR shouldn't be provided in that circumstance. The difficulty that I would have, though, Adam, I'd be interested to hear your views on this, is where you've already made a decision that for whatever reason their underlying condition means that they wouldn't benefit from CPR, and you've therefore made a DNA CPR already. Why that suddenly changes just for the hip surgery? It may be that I just don't understand the clinical context, but Adam, I'd be keen to hear, be interested to hear your views on that.
Yeah, I think that it's always a decision that needs to be taken based upon the clinical situation. And if the patient's situation is such that because of their COPD, if they had a cardiac arrest for whatever reason, they're unlikely to succeed, it's regarded as futile, then just having some other treatment, a hip fracture, it doesn't change potentially the futility of the CPR if it's due to the underlying condition that it's unlikely to be successful. A different example might be if someone has a DNA CPR because of very bad COPD, but they are sitting in a chair eating a sandwich and start choking and their heart stops, well, then you've got a different potential immediately reversible cause. And so in that event, you would at least want to try and reverse the immediate cause by clearing the airway, etc., and taking some steps that might include some limited CPR. The other part of that question was who ought to receive resuscitation if they become profoundly hypotensive from anaesthesia. Again, I think that essentially that is a clinical judgment, clinical decision has to be taken. What is the underlying condition? What's the cause of the profound hypotension? I would have thought that if that happens and it's not being particularly anticipated or expected, then generally you would be looking to provide resuscitation in those circumstances. But it's difficult to talk in complete generalities. Next question, and they're still flying in, so we'll try and get through as many as we can. Can a patient refuse to accept a decision of DNA CPR? Charlotte.
So where a CPR decision is DNA CPR decision is futile, that's a clinical decision, and if the clinical team are not prepared to provide it, a treatment cannot demand treatment that clinicians are not prepared to provide. So the short answer is no. A patient can't refuse to accept a decision. Well, they can refuse to accept it, but they can't demand that it is provided. I would suggest that if you've got that situation, then a second opinion would be helpful potentially. It may be helpful for you to clarify as well whether there are any other hospitals or teams that might provide CPR, and if so, then maybe give cause to reconsider the decision. But no, a patient can't refuse to accept a decision of CPR if that's made on the basis of futility.
And you'd certainly want to be having detailed and carefully documented discussions with them about the risks and the burdens and the benefits, if they're not sort of accepting. But yeah, the bottom line would be that somebody can't demand a treatment or an intervention that the clinical team regard as futile or not indicated. Sorry, I did miss one that was above that question. As CPR is almost always unsuccessful in the over 80s age group, multiple studies show that. Why has this become such a complex issue? Our frail elderly deserve better than CPR, and it certainly is a brutal treatment. That's my comment, not in the question. At the end of their lives, how does the respect form from the Resuscitation Council fit with the legal guidelines? As above, I'm predominantly interested in acute decisions being made in the emergency setting. So yes, why the complexity when certainly in the over 80s age group, the general evidence seems to suggest that CPR is by and large an unsuccessful intervention. Have you any comment on that, Charlotte?
Yes. I think that's a very good question, and we often ask ourselves that as well. I think, as Adam touched on previously briefly, social media and definitely television, I don't think has really helped with DNA CPR decisions. So you'll get patients in casualty or Holby City that go into cardiac arrest and then have a few pumps on the chest, and they're happy as Larry 10 minutes later. And I think there is a general misconception of the truth and the true nature of CPR. As Adam said, it is a brutal treatment, as I'm sure you all know. I think that's quite often not understood by patients and their families. And I do recommend that if you have any leaflets available to families, that you do make that clear, that CPR can often result in broken ribs, particularly amongst the frail, and other injuries. It is a brutal treatment. So I can't answer why it's become so complex, but I do think that it seems to be the direction of travel in society, not to be too philosophical, but in society at the moment where patients and families challenge decisions. They demand the right to treatment. They think they have a right to treatment and all treatment that they want. That's not necessarily the case, but it's just patient expectation, I think, has really become quite far removed from the reality. So in terms of how the respect form from the Resus Council fits in with the legal guidelines, I can't comment on that in detail, but I think it is important that any respect form completed is completed with legal guidance in mind. And I think it's important to make patients aware of the legal guidance. So if treatment is considered futile, then it's made clear to them in the context of the respect form that clinicians, for example, won't be providing CPR as much as a patient might think that they want it. And that's all about communication and good communication at an early stage, as early as possible.
Yeah, it is a communication that's the point that's at the heart of that. And I suppose the only other point I'd make is that, of course, we wouldn't, and I don't think anyone is suggesting that you'd make blanket assumptions about the futility of the treatment purely based on age, although I certainly accept the point that's being made. So the next question, who can legally make DNA CPR decisions, Charlotte?
So a clinician, first and foremost. It's a clinical decision, and so clinicians can legally, healthcare professionals can legally make DNA CPR decisions, and I'm sure that the hospital and trusts will have their own internal processes for that as well. And if you are unclear within your ward or team, hospital trust, whether you can make those sorts of decisions, then do clarify that with management or with senior staff within the hospital. In addition to DNA CPR, who can make DNA CPR decisions, legally make them, the patient themselves can make a decision not to have CPR. If they lack capacity and have an LPA or a deputy appointed, they can legally make decisions. If there's a dispute where a patient lacks capacity about whether they should have a DNA CPR, then a court can legally make that decision as well. So a variety of people in short.
Excellent, thanks. Nothing to add to that. The next question says, so maybe successful, can medical team without this potentially life-prolonging treatment GMC guidance is a bit woolly. I'm not quite sure actually what the question there is. I think it may be, if it may be successful, does that still enable you to take a decision that it could potentially be futile and therefore subject to a DNA CPR? Do you want to address that, Charlotte?
Yes, that's a very good question. Actually, I was discussing this earlier because I do think that the Resus Council guidance is a little bit unclear, and I appreciate that it's difficult to be specific in these circumstances where individual case-by-case decisions need to be made by clinicians on the ground at the time. But if it may be successful, but only for a matter of hours, so it may technically restart the heart, but only for a matter of hours before the patient then inevitably will unfortunately die, and it's prolonging the process of dying. The Resus submissions, or the submissions made by the Resus Council in the Tracy case, say very clearly, as I've set out in one of my slides, that would properly be considered futile. So you're quite right to raise that it's not, may be successful, shouldn't be taken in isolation. It needs to be taken in a slightly wider context. What's the next steps for that patient's treatment, and are they actually going to survive beyond a couple of days? So yes, that definitely needs to be taken into consideration. Yeah.
And if you're in a scenario where it may be successful, as opposed it would not be successful, then you are most certainly needing to look at the benefits, but weighed against the burdens and the risks of the treatment, and undertaking that analysis. Good, thank you. Next, how would you approach the best interest meeting in an emergency, especially in an A&E setting? So patient lacks capacity, wheeled into A&E. What's your words of advice in that scenario, Charlotte?
So decisions will need to be made urgently. I think you can only do what you can do. It depends on the nature of the decision being made. If CPR may be successful, then if it's possible to communicate with the patient, then that communication would definitely be important. And with friends or family, then that too. If you have time, if you simply don't have time, and a decision needs to be made urgently, then you have to make a clinical decision in that emergency setting. Adam, I don't know whether you have anything else that you wanted to add to that.
Not particularly. I think, I mean, you certainly couldn't have a sort of a formal best interest meeting that you might in a non-emergency setting, but those decisions need to be taken under an MCA approach quickly. I think the reality is it probably often means that CPR would be given rather than withheld, because you simply don't have the time necessarily to undertake the analysis. Good, okay. Next question, and I'm just checking the time. Yep, we've still got a few minutes. Could you provide an example of a best interest decision that was taken to court? Well, we can certainly do that. What we're going to do is just prepare a little one-sided A4 takeaway flyer, and I think what we might do is just highlight a case in that. But there are examples, and you do that where there is disagreement or dispute as to the best interests, essentially. So in other words, we think it's futile, but the family, because we'd be talking about a patient that lacks capacity in a court situation, are not of that view, and that's when you get your second opinions and expert evidence. The next comment, worth mentioning respect, which is not legally binding and sets out summary of emergency care, which is, yes, I think that's a good point, because there is a respect form that encourages discussion about how a patient would wish to be treated and cared for, but certainly that isn't binding. But if a patient lacks capacity, would be instructive, certainly, as to best interests. Next question, Charlotte, for comment. We are asked to make treatment escalation plans on admitted patients. Do you advise that we delay such decisions until we have more information? Also, how do your principles relate to ceilings of care, e.g. not for ITU?
That's a good question. I suppose it's important to have, I presume, I think that's a clinical decision really, as in the process that you follow. If your processes are that upon admission, patients are given a treatment escalation plan, then I think that process presumably needs to be followed. It may be that it needs to be kept under constant review. And if you're unsure about anything, then you can absolutely go away and try and get more information before confirming the position. Bear in mind that often with cases, you don't have all the time in the world to go and explore every single avenue. Obviously, you should try as far as you reasonably can to gather information necessary to help you make decisions. But if time doesn't allow, then you have to make the decision with the information that you've got available to you. If the treatment escalation plan could be delayed to obtain more information from either the patient or the family, then by all means, if that's possible, then I see no reason why you shouldn't postpone it. I mean, the difficulty then is that the patient is admitted into hospital and receiving treatment and doesn't have a treatment escalation plan in place. So it's a balancing act, I think, is essentially what I'm trying to say. And I imagine, as with everything, that that sort of plan would be constantly under review.
Excellent, thank you. Next question, has a case ever been brought against staff who have given CPR when a DNA CPR is in place? Charlotte? Yeah,
I'm glad you got to this one, actually, Adam, because I think that's a really good question. And I'd be interested to hear your experience, but my experience is that that there is no, I can't think of a case, I haven't experienced a case where, and I've just lost the question here actually, just to make sure I get it right, that's been brought against staff who have given CPR when a DNA CPR is in place. But there might, I can envisage there might very well be cases out there where a patient is resuscitated and has a poor quality of life, poorer than they deemed acceptable to them, which they made clear to them. And I can appreciate they might be pretty angry about that. So I'm sure there have probably been a number of complaints. I can't think of any prominent case law.
No, I can't. And I suppose given what we're saying about the prospects of it succeeding in many cases, it may be the patients not able necessarily to do anything about that scenario should it arise. But I am certainly not aware of any similar cases. We are sadly at 12:59, and I'm told we must finish at 1. There are a number of great questions still in here, and as indicated, we will respond to those individually. We will issue a little takeaway one side of A4 key points flyer. That might take a day or two to come out. The session is recorded, as I said at the start, and I think someone has asked about that, but yes, the recording will be sent out so you can revisit or listen again to any parts that you may have missed. And on Charlotte's last slide, there are our contact details. Do please drop us a line with any particular points or questions that you have, and we would be happy to do our best to assist. But otherwise, thank you very much for your attendance. Thank you very much, Charlotte, for your presentation, and enjoy the rest of the day.
Thanks, Adam.